refugee issues, prison issues, the condition of our former president. These are, and also the problem that in some cases our judiciary, we believe, lacks complete impartiality of political views, that we are working on all of these issues. But I'm raising them as issues that require further improvements, and we certainly expect further progress. And as you are reviewing the current situation in Taiwan, we certainly hope that this review will also promote further progress in next year. I mean, we'd like to see more human rights reports in upcoming years, and that the issues that we are raising today will see concrete improvements.
Is something wrong with the legislature as well as the criminal process?
Yes.
Is that what you're telling us?
Yes. Well, in the specific case of the refugee law, as I stated, my law is not even, we can't even discuss it because they block it from the agenda. The majority party blocks it from the agenda, so we don't even have an opportunity to review a refugee law. And so, yes, this is also a problem we feel, and it's something that we are working on.
Mm-hmm. Are there still any questions from my colleagues to the parliamentary group? Theo, anybody else? So we still take them and then give you the floor, yes. And then we open up to the NGO community.
Since we have the benefit of two legislators with us, thank you for coming. And this is the only occasion I can ask that question directly to a member of parliament. It is submitted by the government in certain of its presentations that, for instance, many revisions of laws that were needed in order to comply with the international covenants, that they get stuck in parliament. That in fact also it is being stated that because of the tenure of certain parliamentarians was short, then again, so the government is playing the ball to the parliament. And now, can you comment on that? Because it is, it's because all the legislator, as you have said, Madam, the legislator, and also the executive one, and the control one, and others, they all have a responsibility for human rights. And so, is Parliament living up to its responsibilities, or is it part of a process to delay and to get things stuck in the progress? Thank you.
我想回应一下，就是
I would like to respond in this way. I think sometimes human rights can be relative in some cases. I think Taiwan's judicial system is relatively independent and impartial compared with other countries' systems. We believe all the judges exercised discretion and judgment independently, but maybe not everyone can be as equally independent and impartial. So in political cases, some phenomena have resulted in people's doubt and suspicion of the judicial independence. As for the abuse of prosecutorial rights, usually if the prosecutor abused his right to indict, controversy would arise immediately. So the innocence presumption principle is something we need to strengthen and work on. Moreover, for the law amendments proposed to the Legislative Yuan, indeed, there is great standoff between the two parties in the Legislative Yuan. As a result, many of such law and bills, amendments and bills were unable to be passed smoothly. Of course, we look forward to your advice to us in this regard. Thank you. And please forgive us for our having to leave ahead of time.
Thank you very much. If there are no other questions, then I thank you for having taken the time to come to us and discuss these questions with us. And I fully understand that you have to leave for legislative responsibilities. Again, many thanks, and I open up the floor to whoever wishes to take the floor and to provide us with information from your side. Whom may I ask first? Bye-bye.
There's a list. I haven't got it. Which list?
I think that could be. So now we have 2 minutes. Is it this list we are now following? Okay. So we have overstretched the 15 minutes. And now we start with Elder of Aboriginals. 2 minutes. Oh God, I'm not going to now play the.
They're going to meet the
Yeah.
The speaker is right now speaking in his Aboriginal language. Can someone remind the speaker to use a microphone? We would like to use this opportunity to voice the will of people on this island. I hope that Taiwan can be as pure and holy and sacred as the water in this cup. I wish Taiwan can be a bright and warm place like sunshine. I would like to use this ceremony to wish this event a great success.
Makakeway napakaw masaka kinakakalating anay ta sa siyagan makoway siniyakan na wagi kakoyat kekorako sarariyak sa sisone uturarahayal kani utukutuhin ako tegde.
I would like to invite all the experts to dab their finger in the cup so as to get lucky. This is a ceremony we have been practicing for many, many years. By tapping into this water, we express our shared wish to respect each other and live in harmony with one another. Please all stand up. Please all stand up. We wish everyone in Taiwan can love each other, respect each other. Taiwan will be a society full of peace, prosperity, and joy. May justice and peace lead us ahead to our shared future. Thank you. That ends the ceremony.
And now we go according to the list. And the first speaker is Peter Huang. According to the list, there's 5 minutes for each of the following presentations.
Executive Committee member of Taiwan Covenant Watch. Many thanks to all of you for making this unprecedented international review possible, and for allowing me this opportunity to present the short summary of my alternative replies to question number 1 and the related question number 4, CCD list of issues. Question 1, about the need for a National Human Rights Commission as an essential component of a human rights infrastructure for Taiwan. I shall point out 5 reasons. First, Taiwan's 4-decade isolation from the UN and its human rights regime, and the resultant lack of international stimulation and pressure are consequential for Taiwan. One of the consequences is a grave deficit of knowledge and experience in terms of international human rights norms and mechanisms. Taiwan is therefore in urgent need of an infrastructure for the promotion, monitoring, and implementation of universal human rights. Second, 2 DPP administrations from the year 2000 to 2008 made an attempt to build one, beginning with first, the ratification of the Covenants with an Implementation Act, and second, the establishment of a National Human Rights Commission, but without success in both cases, even though CEDAW was ratified to everybody's surprise, thanks to the strong lobbying of the feminist movement. Now that the first has made some progress since 2009 under the current KMT administration, it's time to revive the second as a rare and valuable multi-party endeavor for universal human rights. 3, of existing forms of national human rights institutions, the National Human Rights Commission is the one in closest compliance with the Paris principles. It's also becoming the prevailing form in the Asia-Pacific region. If Taiwan establishes one, it will greatly facilitate regional exchange and cooperation in the only region still without a regional human rights framework. 4, no country should stop with merely the covenants and CEDAW. It's imperative that Taiwan proceed to all other core human rights conventions not yet ratified or acceded to. A National Human Rights Commission will be essential for these undertakings. 5. In the last 3 years, the government has been half-hearted in its implementation of the covenants. An effective National Human Rights Commission will help maintain and hopefully also strengthen the dynamics, even if only for the years to come before the covenant's periodic reports. Maybe I should add a 6th. Many of our weaknesses you must have seen in the last few months, and others that you will ample chance to see in the next few days. Question number 4 about the Human Rights Protection Committee of the Control Yuan. The committee came into existence rather hastily in the year 2000, when there was a heated debate over whether or not to establish a National Human Rights Commission. And the Control Yuan was vehemently opposed to it. With the debate waning over the years, however, its activity has been limited to an annual compilation of maladministration cases with particular human rights significance. Second, the committee does have the power to conduct activity at the request of the Control Yuan or on its own initiative, including investigating presumed corruption practices. 3, and this is one that some of you might have thoughts about, there were proposals for an expanded and reorganized Control Yuan in place of a National Human Rights Commission. But this would, among other problems, require revision of the Constitution, something very, very hard to imagine given existing politics. Thank you.
Thank you, Peter, very much also for staying within the 5 minutes. Now I call on Covenants Watch, Kao Yung-cheng.
各位审查委员哈，我是两公约施行监督联盟的召集人，我是高永成。
I'm the convener of Covenant Watch. I'm Gao Yongchen. I myself am a lawyer. On behalf of the Covenant Watch, on behalf of the more than 40 members of our Covenant Watch, I would like to thank you for coming, and we admire you for what you have done for the promotion of human rights in Taiwan by coming here. And what I want to say at first is I would like to remind you of the effectiveness of the 2 covenants in Taiwan. In Taiwan, we have an implementation act for the 2 covenants, which is a very special act. It is different from other countries when they incorporate international covenants into their domestic law. Taiwan has not been able to participate in the international human rights arena, and therefore there are some doubts and controversies around the effect of the 2 covenants in Taiwan. I think this very issue was already brought out when we ratified CEDAW in Taiwan. The 2 covenants, again, are international treaties, and therefore brings about the issue of its effect. So that's why Taiwan established an implementation act in order to incorporate the provisions of the 2 covenants in Taiwan's law. And not only the provisions of the 2 covenants are incorporated, the general comments made by the 2 treaty bodies have the same effects as the provisions of the two covenants. Now, you have my statement already, in fact, in your hand. So I would like to use my statements that you have. I want to talk about number 3 of LOI. And we have compiled alternative replies, which you can see on your table as well. So, in principle, the NGOs' views on number 4 and number 5 are the same. We agree that the effect of the two covenants are as high as domestic laws, are higher than domestic laws in Taiwan. And in December 2012, when President Ma Ying-jeou participated in the press conference of the publication of the national report, he stated that the two covenants have a prior standing than domestic laws. And President Ma also thinks that even though the Legislative Yuan did not follow Article 8 of the Implementation Act to review all the laws and regulations that are inconsistent with the two covenants, this very fact does not affect the effectiveness of the two covenants, and the government should still apply the provisions in the two covenants. I agree with President Ma, but what I have to add here is that the government did not follow President Ma's instruction. The government agencies still not see the covenants as they have prior standing than domestic laws. If you refer to the LOI ICCPR number 65's reply, you will see that the government's reply for number 65 is in contradiction to its reply to number 4 and 5. In other words, the government thinks that the Assembly Act is not consistent to Article 21 of ICCPR. The government agencies still use the Assembly Act to investigate and even to prosecute the people. This shows that government agencies do not have adequate understanding of the two covenants. And I also want to raise that Taiwan, of course, is not number 1 in protecting human rights. And another situation in Taiwan is that on the surface, it seems that the Taiwanese government is good at protecting human rights. Yet, in reality, the implementation is not as good as it should be. And the judges or the courts do not have in-depth understanding of the two covenants. Even though the courts sometimes rule that there's something wrong with administrative authority, the administrative authority or agencies sometimes ignore the verdict or the decisions made by the courts. And therefore, the Taiwanese government has a lot to do in implement Article 2 of ICCPR. Thank you very much.
Thank you very much. Remain with Covenants Watch, Chen Hung. You have the floor. Thank you.
My name is Junhong Chen. I'm the member of the Covenant Watch and the former chairman of the Taiwan Association for Truth and Reconciliation. And I'm teaching political science at the Soochow University. On behalf of the Covenant Watch and the Taiwan's Association for Truth and Reconciliation, I will make a few remarks observations on the question number 2 and the issue of the transitional justice. As we know, there are 9 co-international human rights treaties, and each has a monitoring body. All of the treaties are interdependent, interrelated, and mutually reinforcing, with the result that no rights can fully enjoy in isolation, but depending on the enjoyment of all other rights. Therefore, in order to fully understand a state obligation under this treaty, it is necessary to see implementation of the states of the provision of all of the treaty as part of the single objective. However, in the government's response to the list of issues, it seems to me that the authority does not comprehend the interdependence of the co-international human rights treaty. In government's response to the list of the issues, the government has replied that it has established a task force that takes charge in selecting the approach of the incorporating international convention into domestic law. However, many co-international human rights treaties were not included, and the authority has not provided more details about this task force. This is my first time to know about this task force. We urge the expert panel to inquire into the mission of the task force, including its function and time frame. In the page 3 of the reply from the government, it's indicated that the spirit of the banning use, torture, and other inhuman punishment has been carried out in our country, and there is no plan to endorse the Convention Against Torture. However, the reply does not give a detailed account of this plan. And the government has to provide more substantive explanation about the huge gap between the content or implementation of a related law and the regulation, unless the authority provides facts sufficient to justify this claim. Is not convinced to assert that the spirit of banning the use of torture and other inhuman punishment has been carried out in our country, and there is no clear evidence showing that endorsing the convention is unnecessary. And in the page 11 of the reply from the government, it is suggested that there is no plan to ratify the Convention of the Rights of Persons with Disability, since the People with Disability Right Protection Act has already referred to the spirit of the Convention of the Right of the Person with a Disability. However, the reply does not give a detailed account of this plan either. As the civil society group has pointed out, the provision of the legislation regarding the right of the person with disability are incomplete, and the department which has primary authority for affairs of person with disability is inefficient. The right of the person with disability in the government, in the Taiwan, still face insufficient legal protection. Toward this issue, Covenant Watch calls upon the authorities to set up a timetable for deliberating, ratifying, and incorporating other co-international human rights conventions into domestic law. Moreover, the authority has to resolve the problem associated with the legal ranking of the convention. Although the matter of the UN membership is unavoidable, there is no reason that the government cannot use the same approach it has used for the two covenants and CEDAW. That's to say, passing implementation act rather than depositing the ratification with the UN. This will advance domestic human rights protection. Thank you very much. In terms of the issue of the transitional justice, I would like to make some observation about the situation in Taiwan. Like most Asian countries, Taiwan has been under the rule of the colonial and authoritarian regime. From the 1947 to 1987, Taiwan has under the martial law rule for 38 years. I think I have 10 minutes, right? Okay, yeah, okay. Yeah, okay, okay. Okay, yeah, sorry. Okay. After the democratization in Taiwan, the government has taken a passive attitude toward transitional justice and done very little on the restoration of the right of the victim. Taiwan is among those few cases in which the issue of transitional justice was not undertook after democratic transition. The Taiwan's inactions not only violate Article 2 of the ICCPR, but also the two principles of the compensation and combat impunity in dealing with human rights violation by the UN. In terms of the victim of rights, during the martial law period, there were more than 16,000 political prisoners. These civilians were charged with sedition and sentenced to imprisonment and executed by the military tribunal. The prisoners were supposed to be able to file appeal through a common judiciary system after the martial law was lifted, but their rights was then restricted by the Article 9 of the National Security Act. As the result, the prisoners was unable to redress the miscarriage of justice, and the government also missed the opportunity to investigate the prosecute the trial, the perpetrators to hold them accountable. Regarding the right to the truth of massive human rights violation has not been uncovered. Unlike many developing democratic countries, the Taiwanese government did not set up an investigatory unit such as the Truth and Reconciliation Commission to find out the truth of the thousands of political cases. Moreover, restriction in recent years on the assessing case file at the National Archives Administration has made it more difficult to reveal the truth for victims and their family, as well as for academics who want to conduct historical research. Without a TRC, may prove to be a significant obstacle to the achievement of transitional justice. So far, the wrongdoers were never persecuted or even named. No single government official was charged with the legal or administrative responsibility. Now, to sum up, Taiwan still has little progress in transitional justice. In dealing with the dark heritage of the former authoritarian regime, the most notable measure is the reparation of the victim. Other issues, such as prosecuting the perpetrators, collecting the historical truth, re-evaluation of the KMT authoritarian regime, so far they didn't arise much debate in public sphere. Toward this issue, we have the following recommendation. Establish a TRC to promote the work of transitional justice. Before TRC is established, collect, sort, and declassify the political files during the martial law period right now. Thank you very much.
Thank you very much. Now we have two speakers of the Taiwan